Hello,
Hey.
very warm welcome and season's greetings to you all from Deka Chambers in this, I think it's our very first festive roundup of developments and highlights in our various practice groups for the past 12 months. Today, we intend to take you by the hand on a festive whistle-stop tour to fly by some of those highlights and developments. So it'll be a bit like watching the snowman, but without the nice music, or the snow, or indeed the snowman. But hopefully we'll have a little bit of magic. Sorry, Ronnie. Sorry, there's no magic either. Today you will be addressed by, firstly, the urbane and very capable Roderick Abbott on civil fraud, and then a rising star of the professional negligence bar, Francesca on professional negligence. Then, thirdly, the learned experience of Cyrus Katrak on disciplinary law. Fourth will be me, old warhorse, just looking forward to a few days off on contentious probate. And then finally, the charming and erudite Conor on insolvency. To add excitement and jeopardy to proceedings, the running order may change without notice if court hearings run over, but I think everyone's here actually. If you have any questions, bit of housekeeping at the end. If you have any questions, please use, I think it's the chat room, the chat box or the Q&A button on your screen, and enter any questions you have there, and we shall endeavour to answer some or all of them at the end, not during, but at the end of the webinar. So without further ado, hand you over.
Francesca's got a question. Yeah, go ahead, Francesca.
Yeah, sorry, I just wanted to give everyone a heads up that so popular is this webinar that we have become the target of a scam, I think, in the webinar chat, which I'm going to use as a funny story / mark of honour. But please do feel free to ignore that, because I don't think anyone should click on the link.
Thank you, Francesca. Very
Top tip
wise
there.
To point that out. Thank you.
Well, without further ado, I'll hand you over to Roderick.
Thank you very much. Could I check that everybody can see the shared screen, the slides that have been prepared?
Yeah.
Yeah, that's great. Okay, fine. So hopefully we'll be able to move those forward. Yeah. So I'm kicking off with a very brief dip of toe into water of civil fraud and credit hire over the past year. As it has been a vintage year in these areas, but there have been a few interesting decisions that may not have necessarily made their way onto your radar and are worth knowing about. So firstly, in the civil fraud space, as the current jargon goes, an interesting decision from the High Court on an appeal about similar fact evidence. Now, many of you will know that where one particular firm, a claimant firm, let's say, builds up a practice in personal injury work, particularly road traffic work, sometimes defendant insurers start to get suspicious as to whether that firm is perhaps playing everything with a straight bat, and or whether the medical experts who they go to, who tend to be the same expert over and over again, are bringing to bear the necessary degree of impartiality and rigour that, of course, their professional obligations and their obligations to the court should entail. And defendants sometimes, when the evidence to them seems sufficiently overwhelming, try to bring in evidence of other claims, similar fact evidence, to bear so that a group of claims can be heard together where the same issue arises. And obviously the benefit from a defendant's point of view of doing that is that where in one case the evidence might not seem particularly compelling seen in isolation, the more cases they can bring which have the similar feature, the more compelling the evidence is, and perhaps the more likely a court is to find that there's something untoward going on. And that was the issue in this case. I won't try to pronounce the claimant's name because I'm sure I will not get it correct, but you have the case name there. Her Honour Judge Backhouse in central London heard the original application. It was an application by the claimants to prevent the defendants from relying on a statement. And the statement was a statement by the claimant's solicitor, and it summarised all the claims effectively that firm had dealt with, brought by a particular solicitor, Ursan & Co, who some of you might be familiar with up in North London, which involved similar facts and in many cases the same medical expert. The claimants didn't like this. They weren't keen on the defendant relying on it, and they essentially took 2 points. They said that the statement was impermissible expert evidence, and therefore was in breach of Part 35 because the defendant didn't have any permission to rely on it, and also the person giving it wasn't suitably qualified, and or it was unreliable because they said it was essentially a cherry-picking exercise where the defendant's solicitor had gone through and chose the cases which he thought would most compellingly make the case of dishonesty, or at the very least lack of credibility on the part of the claimants. So why were the claimants so exercised by this? Well, the evidence showed, this is the evidence in the disputed statement, that 95% of the claims where Ursan was the solicitors included an allegation of psychological injury, which is of course famously objectively hard to disprove. 67% of claimants were recommended for further psychological examination. In 100% of the reports provided by this particular medical expert, he diagnosed a recognised psychiatric condition, and in about 2/3 of them, there was a relatively long recovery period of 2 years or more. The defendant's suggestion was that these were unusually high, and indeed the defendants went so far as to say that this proved that the claims were fundamentally dishonest. Now, that wasn't, whether or not they were fundamentally dishonest clearly wasn't an issue on the application. The application was, could this evidence go in, could it go before the trial judge? Now, Her Honour Judge Backhouse didn't agree with the claimant's position. She held that it was similar fact evidence rather than expert evidence, and therefore didn't fall foul of Part 35. And whilst it might not be probative in itself, it was capable of proving fundamental dishonesty, perhaps with other evidence, and therefore it was contrary to the overriding objective to shut it out and prevent the trial judge from considering it. And she went on to say that if the claimants had concerns about it, then of course they could challenge it. They could challenge it by bringing their own expert evidence if they wanted, bringing that to bear, in particular as in terms of the statistical process that the defendant's solicitor had gone through, and or they could make submissions, of course, to the trial judges to the reliability or weight of the evidence concerned. So she was prepared to allow the evidence to go before the trial judge. The claim was appealed. I put the Court of Appeal there. I think it was actually a High Court judge, so ignore that. But the High Court judge went through the relevant principles. The leading case is called O'Brien, dealing with similar fact evidence. And although there were more reservations on appeal than Her Honour Judge Backhouse had considered, ultimately her decision was upheld. It was upheld that the evidence could go before the trial judge, and that weight and reliability was for the trial judge. Perhaps not surprising in the grand scheme of things, because of course, generally speaking, courts these days are reluctant to shut out evidence if it is probative. As long as it meets a fairly low standard, they'll allow it to go forward and be considered by the trial judge. So if you come across similar fact evidence, that is a very useful authority to be aware of. So that's in terms of fraud. 3 cases in terms of credit hire. Firstly, dealing with illegality, secondly, low value claims under the Part 8 procedure, and thirdly, defamation, which I'll explain once we come on with the case. So illegality. Agbalaya, this was a fairly common scenario that many of you will have encountered in a credit hire RTA type case, where the claimant had a fairly sizable hire claim after an RTA. Her own vehicle, the defendant was able to establish, didn't have an MOT at the relevant time and would have failed its MOT had it been presented, and the claimant wasn't in a position to have made the necessary alterations or done the necessary repairs to get it into a roadworthy condition. Therefore, had she not had the accident and hired a car on credit, she wouldn't have actually had a vehicle that she could lawfully use on the public road. And although it's only a county court decision, His Honour Judge Leatham did go through the recent authorities, and there has been quite a lot of recent Supreme Court authority about illegality, or extirpi, as many of us will know it. Patel and Mirza and Stoffel. And Stoffel, in fact, was a case where Maurice, who sits to my right, was involved successfully to the Supreme Court, led by Andrew Warnock, KC of these chambers. So it's been quite a hot topic recently. And His Honour Judge Leatham essentially applied those principles that have now been more clearly set out to this particular set of facts. And an important observation that he made was that the seriousness of the transgression was not the key to the analysis, although he went on to say that failure to obtain an MOT couldn't be said to be trivial, given its purpose in protecting the public. And one can understand that. Of course, not getting the MOT itself isn't perhaps the most serious of crimes, but the potential consequences of not doing so are very serious. So although it is only a county court judgment, it is very carefully reasoned. It does go through the relevant authorities, and so I think will be highly persuasive at county court level, and I think will probably supersede some other county court decisions. And I've got Jack and Borais at the bottom there, which rather seem to suggest that the trend was away from disallowing claims for illegality in this context. So I think if you're a defendant in particular, it's helpful. If you're a claimant, you need to be aware of it. You need to be aware of the reasoning of it and consider whether it might scupper your claim for higher charges or any similar heads of loss. So that's illegality. Quickly, in terms of low value claims, Burros, most of you will be familiar with the low value claim protocol, that it's fair, the 3 stages, that it's fairly rough justice. In these conjoined appeals, insurers had essentially disputed a district judge's entitlement to find that credit hire claims were proved, because they said the written evidence was inadequate to make out those claims. But the Court of Appeal re-emphasised that the Part 8B procedure is a rough and ready procedure. It's designed to minimise costs. That, in the grand scheme of things, is beneficial for defendants, and therefore they can't complain when they do get rather rough justice, and the same standards aren't applied as would be under the Part 7 procedure. But, and here's a crumb of comfort for defendants, they emphasise that if it did become apparent whilst going through the 3 stages that a case wasn't suitable for Part 8, should go on to Part 7, that the court had essentially an unfettered power to transfer it onto Part 7, and the White Book was wrong to suggest that it would only be in rare and exceptional cases that should happen. So if you're dealing with this type of work, be aware of Burros. Finally, defamation. Now, I can't promise that this is going to be the Wagatha Christie trial of the century in the credit hire context. However, it may well be an interesting watch if it goes to trial. It deals with the 2 articles which were published in essentially a trade magazine called Insurance Times. I'm sure thrilling bedtime reading, which dealt with a particular credit hire company that many of you will know called Direct Accident Management, which is part of a wider group called Anexo. And essentially these were uncomplimentary articles, as you can probably tell from the headlines which I've put up there. Credit hire shark circle as market reacts to excessive costs, and rogue agent aggravates industry with trumped up credit hire costs. One of the articles referred to a specific case where a credit hire claim of nearly £500,000 was successfully defended by Aviva. And the second one examined the relationship between Direct Accident Management and Bond Turner, who those of you who are familiar with this area will know are part of the same group. And this was a preliminary ruling, so it wasn't a substantive trial, but in defamation cases these days, there's a preliminary hearing where the court determines meaning, and then the substantive issues are dealt with at trial, such as a plea of justification, if indeed the defendant wants to raise it. So the court deemed both of them to be defamatory, of damns. Perhaps unsurprisingly, the precise meanings were defined, but one can readily understand that if this case goes to trial and the defendant's news organisation tries to plead justification, in other words, to say that the claims were true, this could shine a real spotlight on the credit hire industry and what's going on, which will no doubt be hotly contested by the claimant, who will say everything he did was above board. So it could be a bit of a showstopper, and it could have potentially very serious implications for the industry as a whole. So watch this space. That's my lot done. Next up is Francesca on professional negligence. I'll hand over to Francesca. I think you're on mute, Francesca.
Oh, sorry, Roddy. I was just
Okay.
complimenting you on how incredibly illuminating that was. Moving on to professional negligence, and Roddy, you're in control of the slides, I think.
Yes, we're going to do a sort of Downing Street COVID briefing where you have to say next slide, please, and I will activate it. So go ahead.
Yes, well, Professor Whitty, next slide, please. Professional negligence, always busy, but it has been particularly busy in 2022 with a range of interesting decisions from both the Court of Appeal and the High Court on matters which affect everyday solicitors' practice, and which those of us who practice in this area should really take note. Before I move on to the first case, which is Miller and Irwin Mitchell, the background to solicitors' scope of duty arguments is really a 2016 decision with which you're probably all familiar. It's called Minkin and Landsberg. What that said was a solicitor's duty is limited to carrying out the tasks which the client has instructed him or her to do, and the solicitor has agreed to undertake. And the court must be wary of imposing on solicitors duties that go beyond the scope of what has been requested and undertaken to do so. Two decisions recently which have reaffirmed that this is the correct approach. Spire Property Development LLP in Withers, it's a 22 decision of the Court of Appeal. It's not on the slide because I'm not going to deal with it in any detail. But that considered scope of duty issues, and the only interesting feature of it for these purposes is that it repeated the statements of principle set out in Minkin, and also cited with approval the statement of Lord Justice Patton in a 2018 case, Lyons and Fox Williams, which said that neither the Credit Lyonnais case, which is the rotten tooth analogy, or Minkin were authorities for the proposition that a solicitor is required to carry out investigative tasks in areas that he has not been asked to deal with, however beneficial to the client that might in fact have turned out to be. So that's the backdrop. Against this, we've got three decisions which I'm going to briefly rattle through. The first is Miller, a decision which has been, I think, very extensively looked at and is in fact subject to an appeal to the Court of Appeal, which I understand is going to be listed for a hearing early next year. In Miller, the successful defendant solicitor's firm was represented by Andrew Spencer, led by Andrew Warnock KC of Deka Chambers, and it relates to a claimant who fell down some stairs on holiday. So it was an international personal injury claim. She saw an advert for a legal helpline and called it and asked for some advice about her potential personal injury claim. And she was referred on to the defendant's international travel litigation group, who then assisted her with the bringing of a claim. But the point about the case was the status of the advertisement and whether or not a retainer had come into being. At what point had the retainer come into being as between the client and the solicitor's firm? And what the court said was that the defendant's advertisement did not amount to an offer to provide legal services. Going back to our old lectures on contract law, offer and acceptance, the very first thing that you get taught in contract law, it did not amount to an offer. It was an invitation to treat. effectively. It was an invitation to the public to call the helpline to see whether the defendant could help by providing legal services to be negotiated and agreed on down the line. No implied retainer had therefore arisen, and so the claimant's claim of negligence on the part of the defendant's solicitors falls away. Interesting case. We'll see what happens in the Court of Appeal, but I would suggest that everyone interested in this keeps watching. Next slide, please. Another case on the on when a retainer comes into existence. McDonnell and Das Legal, it was a costs decision, slightly weirdly, but it did resolve the issue between the claimant and the defendant as to when an implied retainer and a firm of solicitors comes into being. And what the claimant said was, well, these solicitors have acted for me many times in many different actions. We know each other well. We've got an existing commercial relationship. I had a chat with them for a few minutes about this new case, and they agreed that they would look into it. And that conversation, lasting a few minutes, gives rise to an implied retainer against which I can seek damages from the solicitor's firm, who I now allege to have been negligent. And what the court said was, no, if you want to be able to demonstrate that an implied retainer has come into existence, you have to fulfill quite strict criteria. The first is that where there is no express retainer, an implied retainer would only be in existence if the test for implication was met. And that test is one of necessity rather than convenience to the claimant. A retainer is not just implied because it makes sense with the benefit of hindsight. It has to be an actual requirement of the litigation across the board. So very important to bear that in mind. The other interesting facet of that case, in my view, is that the fact that there was no express retainer was in fact powerful evidence to support the argument that there was no implied retainer either. Plainly, if you are a solicitor's firm entering into any sort of commercial agreement with a client, you have to protect your position by ensuring that there is an express retainer in place. If you haven't done that, the court is going to take a dim view of the claimant who says, oh, well, we had a chat about it, and a retainer can be implied from that. Again, I think useful authority and good guidance from the court. Next slide, please, Roddy. This is the last case. And by the way, I hope you're all really enjoying the thematic illustration of my slides, because this took some work and engagement with the PowerPoint program. Here we've got, I think, an actual wrapped Christmas present. Sorry, I digress. Orium Real Estate and Mishcon de Rea. Again, a really interesting decision. Again, considering the moment at which a retainer comes into existence and the matters that will fall within the scope of that retainer, the firm had not been instructed by Orium Real Estate to represent them under a general retainer, the sort where, we may instruct you to do this, that, and the other on different cases, and it all falls under the scope of the same thing. But instead, they had been instructed to advise on a discrete matter-by-matter basis by way of engagement letters. So for each thing that the firm was instructed to do, there needed to be a fresh engagement letter setting out exactly what was being specified, what needed to be done, and the firm then agreed to undertake that. This is important because if there isn't a general retainer of the sort that the claimant was alleging, it was necessary to identify the precise contractual basis under which the firm acted. And that was something that Orium Real Estate just couldn't do in this, because they were in effect asserting that there was a general retainer in place. Read fairly and objectively, and having regard to the circumstances in which the letter was agreed, so this was the particular letter of engagement that was the subject of the allegedly negligent advice, the agreement envisaged a continuum of drafting and negotiation between the law firm and the tenants of the property which was the subject of the litigation, with a view to documenting an agreed surrender of a tenancy. I don't need to go into the facts of the case, but clearly it was a property case, and in it, each stage of the litigation had to be managed separately, so it was possible for Mishcons to say, what you think you've asked us to do is not in fact what you have asked us to do. And in that way, they were able to defend successfully the professional negligence claim brought against them. I hope that is interesting. I think is there one more slide, Roddy?
There is, it should be up now.
Yes, thank you. Effectively, this develops the argument slightly. But the important point, of course, is that there is no duty of care. What I've said in the slide is that the judgment is really worth reading for paragraphs 33, 69, 98, and 106 as a useful exposition of the way that the courts will deal with arguments about scope of duty and retainers, especially applying the recent 6-stage test in the MBS Grant Thornton case, with which we're all familiar, although possibly even more confused than before the Supreme Court decided that we all needed an easy roadmap. Any questions about that, please do put them in the chat box or send me an email. Thank you.
Thanks, Francesca. Cyrus is going to present on disciplinary law.
Hello, everyone. So yes, this is a fascinating for me subject and a nice little sideline. Disciplinary law. And I'm not going to talk to you about any recent cases because disciplinary law moves at the speed of a slow tortoise sometimes in terms of principles. But in my experience as a disciplinary barrister, and that means I act for doctors and dentists, and I also sit in the NMC, which is the Nursing and Midwifery Council, as a legal assessor, which means I have to make sure that the panels get the law right. Over the last year, I've seen an increasing trend, and it's this, that nurses will often attend hearings virtually, because since COVID, virtual hearings have become a thing, and that means the uptake of participation in hearings is much greater. And they will often instruct solicitors at the very last moment. Once an allegation has been made against them, they sadly will often lose their job and find themselves unable to pay their union dues. And that usually means that they're unrepresented until moments before the hearing, when they decide to go and find a solicitor. And life being as it is, they look in the directory and they usually end up finding personal injury solicitors. All good and well. But over the last year or so, I've noticed an increasing trend, which is to do with reflection, insight, and remediation. So if we could start with the first slide, please. Now, the great thing about this area of law is that virtually all professionals are regulated by their professional body. Nurses, doctors, dentists, vets, accountants, physiotherapists, they all have their own body. And what is great about practicing in this area of law is that the rules and the framework, and indeed the case law, is virtually the same for all of them, save for a few minor tweaks. So you will see that a number of these slides refer to doctors. They could easily just as equally apply to vets or nurses. Nurses, of course, are by far the largest professional body in the country. And indeed, I did hear a statistic once, and I've never checked to see whether it's true or not, that the Nursing and Midwifery Council is the 3rd largest employer in the world, following on just behind the Chinese army and the Indian railway companies. Anyway, take that as it may. The consequence of that is there are an awful lot of cases involving nurses. So when I sit as a legal assessor at the Nursing and Midwifery Council, they are ably represented, but often there is a lack of documentation on their part of reflection, insight, and remediation. And that's not something you can do the night before a hearing. You've really got to start, as if you're advising somebody who is in regulatory problems, to start this process of reflection, insight, and remediation as early as possible. Now, why is this possible? Well, you'll see in this slide that I make the point that things go wrong. It can be clinical errors and misjudgments, and it can also be misconduct, where you've stolen money or stolen drugs or turned up for work drunk, or it could be that you've got another health problem. or that your language is very deficient. Now, reflection, insight, and remediation are critical for the panel when they determine whether or not a nurse or a doctor, a vet, or accountant, and so on and so forth is still fit to practice. Now, just to do a very quick detour, all these professional bodies have a three-stage process. The first stage is the charges are read to the nurse or the doctor, and any unadmitted charges have to be proven by the regulatory body. So the first stage is the fact stage, and it's very much like going to the magistrate's court or the criminal courts. If any facts are found proved, the panel then go on to the second stage, which is to decide whether or not that nurse or doctor or vet's fitness to practice is currently impaired, whether they're safe to carry on working currently. And it's at this stage where reflection and insight and remediation become really critical. Reflection is a word of general import, and there's no great technical meaning to it, other than it involves a serious thought or consideration of the circumstances that led to the things that have gone wrong, or the panel have found have gone wrong. And it's also learning, insight is learning from this reflection to gain an accurate and deep understanding of what needs to be done to make sure it doesn't happen again. We can have the next slide, please. Not happening again is critical. Now just pause there. The GMC and the BMA make it absolutely clear that reflective practice should be the part and parcel of everyday life for healthcare professionals. Okay, so nurses and doctors and indeed other professionals should constantly, and I suppose barristers as well and solicitors, should constantly be reflecting on how their practice is going and where it is going wrong, and positive as well as negative matters should be considered. So if we can have the next slide, please. You'll see my sub-point 3 there. Both positive and negative experiences should be considered. Any experience, including a conversation, for instance, with a colleague, a significant clinical or professional event, or a period of time, can generate meaningful reflections, insights, and learnings. If you are a professional who is in front of his or her regulatory body, they will be very astute when they're looking at any evidence that you've shown that you've considered what you've done, whether or not you've just been ticking the boxes at the behest of the solicitors acting on your behalf. Could we have the next page, please? So insight then. All regulators consider insight as a mitigation factor when considering fitness to practice. But if there isn't any insight, conversely, persistent lack of insight into the seriousness of the actions and the consequences can be an aggravating factor and more likely to lead to adverse findings and increased likelihood of sanctions. Now, that might be surprising, but it very often happens in healthcare regulatory bodies that when it comes to the sanction stage, deciding whether to give you conditions of practice or to strike you off, if the panel take the view that you, the professional, really haven't had any insight into what you've done wrong, or why your actions might be viewed as reprehensible by members of the public, they are very likely to increase the penalty that you end up paying. And that can bump up something from, say, a suspension to a strike-off order. So it's very important. Have the next page, please. So why did I say at the outset that it's very important this is done early? Well, look at bullet points 2 in this context. Insight can be demonstrated through training and training courses. Most healthcare professionals can find these training courses on the internet for a very few pounds and can be done online. And really, regulatory bodies don't mind people doing these training courses online. But of course, if your nurse or doctor or vet shows a great wodge of training certificates dated 48 hours before the hearing takes place, the panel aren't going to be impressed. You've just absorbed a huge amount of information, you've not put it into practice. Where's that going to take you? Conversely, if you've been undertaking training courses and such for months, if not years before the final hearing, they're going to be very impressed. Doctors, when they're investigated, they have an initial selection of charges put to them very early on. It's called a Rule 7 charge. And basically, Rule 7 means, dear doctor, we think you've done something bad. This is what we think you've done bad. Please can we have your observations? If a doctor at that stage can say, oh, okay, hang on a moment, I accept these charges, or accept some of the charges, and I've got great insight, and I've reflected on why patients are going to be harmed if I do this again, or and so on and so forth. Very often, the whole process stops at Rule 7 stage. It never gets to a final hearing in front of a panel. Most doctors don't do that. So a lot of hearings go all the way to a final hearing. Next slide, please. Now, this is all very good and well if you've been curt with colleagues, or you've been bad at your practice as a doctor in that you've been sloppy in the medication, but some classes of case are very difficult to remediate. And I put those at the bottom. The obvious one is a criminal conviction, and certainly ones involving dishonesty. How can you really show somebody that you're not going to steal money again, or you're not going to fiddle timesheets? Very difficult. That's what, obviously, the criminal courts deal with all the time. Sexual misconduct and impropriety. If you're dealing with a nurse who is charged with having child pornography on their phones or their computers, how can they really show remediation and insight into that? They can say, oh, I've learned and I won't do it again. But is the panel really going to buy that? And similarly for drug or alcohol use, that's a little bit easier because, of course, if you can show that you've been free of drug and alcohols for a period of time, that tends to support your case on insight and remediation. And often regulatory bodies will actually say, right, off you go and get drug testing every few months just to show that you're clear. And that's quite a good indication. If we could skip on perhaps 4 pages to examples of remediation, seeing as time is running a little show. Thank you. So there I've set out a couple of examples about remediation. So the first one is a doctor who's been dishonest could be asked to go on a probity and ethics course and then write a reflective account of what their dishonesty was and what they've learnt. Suboptimal practice, they could be dealt with by supervision. Behaving badly at work or in their private life, might go and see a behavioural psychologist. You can imagine that some of the crusty old consultants I have to do with look at this as some sort of witchcraft and they're not going to engage with it. And I've been told on a number of occasions by doctors, well, I'm not going to do this. This isn't what doctors should be doing, talking to clinical psychologists about their bad behaviour. Fine. They're going to be in there for the high jump if they don't. Finally, on the next page, I won't give all those examples, but they'll be available too. You'll see that apologies are also really important and very rarely ever done. Obviously, that needs to be seen in the context for doctors in terms of, does that open up dangers of clinical negligence claims and the such. You'll see at the bottom, the GMC provides a rudimentary template for doctors for creating personal development plans, and that's a good starting point. Right, last page. Why is this so important? A GMC analysis of cases for doctors in 2021 relating to conduct and performance. Of 60 cases in which doctors apologised or had remediated since the event, 5% were erased from the register. In contrast, where the panel considered the doctor hadn't demonstrated insight, 59% were erased. I leave you with that, ladies and gentlemen. Thank you very much for listening to my talk, and if you've got any questions, please raise them in the chat box. Thank you.
Hello. Now it's my turn to deal with that most festive of subjects, contentious probates. If we can just bounce 2 slides on, sorry. The most important principle, I'm going to try and skim this as quickly as possible. The most important principle in contentious probate, or in any probate, is testamentary capacity. When someone is making important life decisions, it's vital that they are in the right frame of mind to do so, and hold the appropriate mental capacity at the time. That when they execute a will or amend an existing will, they must understand what they are doing and the extent of the property which they are giving away in the will, not to the minutest of detail, but roughly. And according to the common law test in Banks and Goodfellow from 1870, which has stood the test of time, they need to be able to comprehend and appreciate the claims to which they ought to give effect. And for this purpose, no disorder of the mind must poison their affections, pervert their sense of right, or prevent the exercise of their natural faculties. No insane delusion must influence their will in disposing of their property. Just recently, before Mrs. Justice Folk, as she was then, the case of Clitheroe and Bond in October of this year needs to be highlighted. This was a case where the High Court upheld the Deputy Master's refusal to admit 2 wills to probate due to testamentary incapacity based on insane delusions of the mother. The mother's wills, she had 2 wills, both disinherited her daughter and left the whole of her estate to her son. The daughter alleged that the mother was under an affective disorder of the mind, partly to do with an insane delusion that the mother, in her final years, believed the daughter had invented allegations of abuse against the father, despite the mother having previously divorced the father because of the actual abuse, the very abuse that he had inflicted on the daughter. So in effect, she had deluded herself that these were simply allegations by the daughter. Yes. And then, despite there being handwritten instructions from the deceased explaining reasons for excluding her daughter, the daughter was able to produce enough evidence of testamentary incapacity to make her case. There were a number of other factors, but there are important points in this case. Mrs. Justice Folk found that although the deputy master had not properly analysed the insane delusions, in that they needed to be a fixed delusion and not capable of being displaced by rational persuasion, for example, overall she found that testamentary incapacity should stand, and the 2 wills were revoked. Over the page, the 2 points of interest from this case are highlighted because this case confirms very much so that the correct test for incapacity is the Banks and Goodfellow test from 1869-1870, rather than the test under the Mental Capacity Act in 2005. I mention this because there was, up until about 2014, a seam of jurisprudence, a seam of cases where it was thought that the Mental Capacity Act was simply a statutory restatement of the Banks and Goodfellow test. But they are different, and this case confirms it, amongst other cases. There are big differences in the 2 approaches, especially where the burden of proof lies. Where under the Mental Capacity Act, it's presumed that all adults have capacity, whereas under the Banks and Goodfellow test, common law test, the burden of proof shifts. So if a will or a deed is executed and on the face of it has been executed properly, then the presumption is that there was capacity. But if there's some evidence that raises a real doubt about capacity, then the burden shifts to the propounder of the will, the son, in this case. Sorry, let me just go back. The case also was a very good analysis of insane delusions. Sorry, go on.
No?
Yeah, please. Now, the second case I want to highlight is more on a practice point. Antonio Williams, the High Court made an award for of £50,000 for reasonable provision to the deceased 12-year-old son under the Inheritance Act. Nothing unusual there, but one of the significant features of this case was that the award was made before a grant of representation had been issued in the deceased estate. a note in the current White Book at footnote 57.16.6 under Part 57 indicates that there must be a grant before an award. And normally people then are, representatives are then captured in that 6-month period where the limitation period for an Inheritance Act claim expires 6 months after the grant. But this case is important because, of course, if the claimant knows the contents of the will prior to the grant, and in many cases you don't know the contents of the will because, of course, it's a confidential and private document until a grant's to be made. But in some cases where the claimant knows of the content of the will and disagrees with it and feels that they have a claim under the Inheritance Act, then they can get on and make their claim before being rushed in the 6-month limitation period. Next. The last case I want to highlight isn't strictly a contentious probate case, but it has some relevance to probate. And this is the Supreme Court case of Guest and Guest, which is a proprietary estoppel case. The son of a farming family was promised that he would inherit a substantial share of the farm and business of his father. It's actually called Trump Farm. In reliance on this promise, the son worked on the farm for 30 years for long hours and little pay. The family then fell out around Christmas, I think it was, and the father changed his will, disinheriting, absolutely favouring his other son. At first instance, the High Court found that a proprietary estoppel had arisen. The question before the Supreme Court was to select an appropriate method to quantify the remedy for the son once the equity had been established. The problem with that, of course, was that the equity, the proprietary estoppel had arisen based upon the future promise of inheriting the estate after the parents had died. How on earth do you quantify that? Lord Briggs, in the leading speech, favoured the starting approach of what was called a fulfilment of promise, which was sort of like an expectation loss, to be tempered with considerations of practicality, justice, and proportionality. So, does he get the whole estate? Does he get the farm? Does he get the business? And is that tempered and reduced to take into account claims by other children within the estate as well? Lord Leggett, dissenting, preferred the starting point as simply compensation for the detriment suffered as a loss based upon the broken promise. So it's sort of more of a tempered approach and perhaps more respectful of the speculative nature of the claim. The interesting takeaway points relevant to probate, of course, are, as I've already indicated, that the estoppel claim was against the estate of the parents, which had not as yet been devised. The parents were still alive, so it was an enforcement of a promise to receive a share of something in the future, which may or may not be in existence when they do die, for a plethora of other reasons, which is why Lord Briggs emphasised the need to reduce the amount of the award in accordance with an accelerated clean break early payment. In any event, the real question arising from the case should be, in terms of probate, how to avoid the distress, cost and uncertainty of prolonged court proceedings between family members. Don't make promises at Christmas, certainly, where we are replete with sentiment and, of course, booze. We must be careful of the promises we make to family members, especially as to what we intend to leave them in our wills. Perhaps keep them close to your chest, and above all, be fair amongst your family members. Those are my Christmas messages. Thank you very much. Oh, forgive me. Perhaps one last message. This is, again, on a more practical level. From October, the forms for caveats have changed to a PA8A form. And from October, you'll no longer be able to enter or extend a caveat by email. I don't quite know why. It seems utterly bizarre, but there you have it. Thank you very much.
Thank you. Conor is up next, and he's going to be.
Thanks, Maurice. Thanks, Roddy. I'm going to talk about 3 insolvency cases this year. First, a Supreme Court decision on directors' duties, not to shareholders, but to creditors of companies. Second, a Court of Appeal decision on the personal liability of former directors of insolvent companies. And finally, a High Court decision on enforcement actions against pensions of bankrupt debtors. Starting with this first case, BTI and Sakana. The facts of this case were simply that directors of a UK registered company had paid out 135 million euros, nearly all of its net assets, to a parent company, Sequana. The company wasn't trading and had been set up just to hold money for contingent pollution liabilities. But it was nevertheless, so it was nothing unlawful in this payment, but it was nevertheless at a real risk of insolvency. 10 years later, after that 135 million had been paid, the company did in fact become insolvent, and the company's assignees then sued the directors for breach of duty to creditors. So next slide, Roddy. So looking at the question of whether the directors had owed a duty to company creditors, Lady Arden said in her judgment, this is a momentous decision for company law. It's as momentous a decision as the court's recent decision in Patel and Mirza was for the law of illegality. And she noted, effectively, it raises a fundamental question, because in some jurisdictions like Delaware and Canada, they take the view that directors owe no duty to creditors, whereas Australia and New Zealand adopt a different approach and say that when a company at least approaches insolvency, directors' duties do have to take account of creditors. So the Supreme Court had to decide in this case whether to continue a line of English authority, which began with a Court of Appeal case, West Mercia and Dodd from 1988, and other first instance decisions, which predated the enactment of the 2006 Companies Act in this country. Or alternatively, the court had to decide that such a duty to creditors was contrary to the principle of limited liability of companies. The Supreme Court in this case was unanimous in deciding that such a duty to creditors should be recognised. So in terms of the content of this duty, the court said it preserves the director's duties. The way the court analysed it was it preserves the director's fiduciary duty to act in the interest of a company, but modifies that concept so that instead of the company's interest just being the interest of shareholders, it was expanded to include the interest of creditors. And effectively, that reflects the real fact that creditors have an economic interest in the company's affairs. So effectively, what directors are going to have to do when they find their companies approaching insolvency is perform a balancing exercise between the interests of shareholders on the one hand and creditors on the other. What Lord Reid said was that as a general rule, the more powerless the state of a company, the more the interests of creditors will predominate and the greater the weight to be given to their interests. So in what circumstances does this duty arise? Well, again, in the present case, there was a real risk of insolvency when that 135 million dividend payment was made, but it wasn't at the stage of insolvency or bordering on insolvency. And for that reason, the court was unanimous in rejecting the argument of the appellant that the duty had arisen in this present case. The court then went on to consider obiter when that duty would arise. But of course, because that wasn't at issue in the present case, those comments won't be binding on other courts, although of course they will take them into account. And the general consensus was that a company had to be insolvent, either insolvent or bordering on insolvency before this duty would be triggered. There was also some comments from Lord Briggs and Lord Kitchen that it might be essential that the directors, the duty might be triggered by knowledge, actual or constructive, of directors of insolvency. But again, there wasn't agreement on that, and that argument has been left for another day. Moving on quickly to, I think I forgot, yeah, this slide. PSV and Langdon. This is the Court of Appeal case considering the proper construction of Section 217 of the Insolvency Act. So just to remind you, Sections 216 and 217 of the Insolvency Act, they're aimed at what are sort of regarded as phoenix companies. So a lot of you might be familiar with directors that run companies into the ground and then immediately move on and start another company and continue trading under effectively the same name. Well, that's prohibited under Section 216. And Section 217 says that if a director acts in breach of that 216 prohibition, then they're liable personally, jointly and severally for the debts of the insolvent company. So Mr. Langdon had been a director of a company, Discovery Yachts Limited, that had been sued, entered in administration immediately before trial. The claimant had permission to continue against the company and obtained damages. So Discovery Yachts was a prohibited name, but Mr. Langdon was nevertheless trading under it. So next slide. So what Lady Justice Asplin in the Court of Appeal held was that under Section 217, Mr. Langdon was personally liable for the debts of the insolvent company. He said, in my judgment, the natural and ordinary meaning of the language used in Section 217 is quite clear. And of course, that section appears within Chapter 10 of the Companies Act, which is headed malpractice before and during malpractice before and during liquidation, penalization of companies and company officers. And of course, Section 216 also makes it a criminal offence, punishable by imprisonment, to use a prohibited name. And the court considered whether this might lead to injustice, but noted that under Rule 22 of the insolvency rules, those rules, that rule expressly allows directors to come along and ask the court for permission to use a prohibited name. So the director in this case only had themselves to blame for the consequences of their actions. I'll move on then to the final case I've got. Back in green, this is a duplicate slide, so can we go to the next slide? Thanks, Ryan. A very interesting case because it involved a high-profile art fraudster, Matthew Green, who's currently wanted by US authorities for money laundering and is hiding out in Alicante, Spain, I believe. The claimant had obtained judgment against Mr. Green for deceit, so that's a judgment in fraud, which of course survives a claim which survives bankruptcy. But in any case, Mr. Green was bankrupt and all of his assets fell into the state in bankruptcy. So there wouldn't have been much left for the claimants to get from those assets. He did have a pension, which was extremely valuable. So next slide, please. Thanks. And the claimant initially sought to enforce against that pension by seeking a charging order against Mr. Green's interest in it. That failed because there are statutory protections of pensions. So the claimant then changed tack and sought an injunction under Section 37 of the Senior Courts Act, which would effectively order this fraudster to draw down his pension and pay it into a bank account. And then the second limb of the claimant's strategy was to ask the court for a third-party debt order to secure those assets, those pension funds that have been paid into bank accounts for Mr. Green. And again, running out of time, but the judge considered that, noted the public policy in favor of preventing fraudsters from prospering, and held that it was just, equitable and convenient to make those orders. So that was considered a very unusual case to allow enforcement against the pension. There are two other cases by Deputy High Court judges, which I've mentioned at the bottom there, Lindsay and O'Loughlin and Brake and Guy, in which deputy High Court judges have followed that case and also made enforcement orders against pensions in the form of injunctions, to be followed by third-party debt orders. So it's one more reason to consider pleading fraud. I know practitioners, for good reasons, are very wary of pleading fraud, but this is, when dealing with an individual, yet another reason to consider pleading fraud. That gives you that extra protection. So I can see that we've run over time slightly, so I won't say anything more, but again, happy to answer any questions, probably by email at this point.
Thank you, Conor. Well, I think that completes proceedings for today. Thank you very much all to you all for your attention. Our email addresses are all there, so if you have any questions for us individually, please do get in touch. We'll be delighted to hear from you, and we'll do our best to assist. Thank you all very much for attending, and best wishes for the festive season to you all.
Merry Christmas, everyone.
Merry Christmas.
Merry Christmas.
Bye for now.